Hi Cyber Class, it's Professor Opterbeck. This is just a quick video on the Van Buren and HiQ cases. So let's look first at Van Buren. And Van Buren really resolves, or sort of quasi-resolves, I suppose we should say, an issue in the CFAA about this question of access. And as you're reading the CFAA, and as you listen to the first video explaining the CFAA, you know that the basis for a good part of the statute is really about access or authorization, whether someone has gotten access without authorization or access in excess of authorization. And so what does this question of authorization mean in the CFAA? And there was a circuit split about whether that means technological kind of authorization, like a password or encryption or something like that. So what we might more classically think of as hacking, as cracking a password, breaking encryption, or if it includes not only code-based restrictions but also policy-based restrictions. So for example, every employer, like Seton Hall University, for example, has acceptable use policies for its computer systems. I can use this university computer systems for the purpose of my teaching and research and so on. I can't, not supposed to, according to the policy, let's say, use it to provide insider information to a competing law school for purposes of admissions or something like that, right? Violating that policy would be a contractual violation. And maybe it's a trade secret thing, right? But is it a Computer Fraud and Abuse Act claim, whether on the civil side, because remember you can bring a civil case under the CFAA, or on the criminal side. And you actually had in the Ninth Circuit a case called Nozzle that involved a criminal prosecution of an individual who had taken information from his employer to set up a competing firm. And then there were some other cases like that as well. So some circuits had said, no, it's only code-based. Some circuits had said, yes, it can be policy-based. And the Van Buren case really comes down on the side of saying policy-based restrictions alone are not a violation of the CFAA, or circumventing, right, getting around or accessing a computer beyond what merely a policy-based restriction says is not a violation of the CFAA. So in Van Buren, we have a police officer. As a police officer, he has access credentials to the police officer system that looks up license plates. The police office policy, of course, says he can use that in the course of his police business, trying to track down a hit and run or something like that. There's some suspicion that he's in cahoots with some kind of bad character in the area. The FBI gets involved, a little unusual, but I guess there's a suspicion of a potentially corrupt cop. The FBI gets involved, they set up this sting operation, and indeed the guy falls for the sting. He gets license plate information in exchange for money under this sort of a somewhat elaborate setup of this undercover guy. But he clearly violated police office policy, but he used his legitimate credentials. And he is prosecuted under the CFAA, and the question is, did he, in fact, exceed his authorized access? And, as we said, the court ultimately says, no, he didn't. Really, this is technology-based. And if we look at the analysis by Justice Barrett, Justice Barrett, as you may know, is an originalist and a textualist with respect to the Constitution, and a textualist with respect to statutes. So she's trying to do this textualist analysis of the words in the statute. And whether you think her reading of the statute is persuasive or not is partly going to depend on whether you think textualist readings of legislation is persuasive. And even if you are a textualist in legislation, whether her reading of this relatively, what ends up being kind of a Byzantine set of phrases, really makes sense or not. In any event, she ends up saying the defendant's reading of the statute is correct, and the defendant's reading, she says, is basically a gates up or gates down inquiry. So the gates are up. There's no sort of technological gates keeping someone from access to the content. Not a CFAA case. The gates are down. There's some kind of technological barrier to access, and the accused has somehow messed with that technological barrier. That's potentially a violation of the CFAA. And even though Barrett is a textualist, she still looks at policy considerations beyond the language of the statute and basically takes the line of those circuit courts that had rejected policy-based violations of the CFAA, who said, look, there's all kinds of terms of service restrictions that people don't even know exist that they might be violating. There are all kinds of employment policies that people may never read and not really know that they exist, and those shouldn't be crimes, right? Those shouldn't be federal crimes. Like, again, maybe they're a breach of contract, maybe somebody gets fired, something like that. That's all civil stuff, right? Shouldn't be a crime. She takes that position of the CFAA. So we have that in Van Buren. Now I said, Van Buren sort of settles this issue, but as is it technological or only policy based? But then we get a case like HiQ in the Ninth Circuit, and you'll notice that HiQ, there had been an opinion in the Ninth Circuit. It had actually gone up on certiorari. The court vacated and sent it back down for reconsideration in light of Van Buren. And so here we have the Ninth Circuit reconsidering its judgment in this case in light of Van Buren. And this is an interesting case for a few reasons. Now one is simply, how do we now apply Van Buren where it's not entirely clear whether we're talking about technological gates or policy gates or some hybrid of those things? And in particular, how do we deal with web crawling and web scraping? Now, if you're watching this and you haven't watched the videos I gave you on from different vendors on web scraping, I want you to pause and go and watch those. Now, when you watch those, I'm not endorsing that you use any of the tools that are mentioned in those videos. You might, and there might be legitimate reasons to use them. But I want you to notice that those tools are designed to scrape information from the internet, from the public internet, and some of the videos will talk about ways in which those tools are intentionally deployed using proxies, using headless browsers, in order to get around sort of combined policy and technological restrictions on scraping. So HiQ is an interesting case because it takes a pretty strong stance in saying that web scraping of a public-facing website, notwithstanding that the site has some technological measures to prevent scraping, is not a CFAA violation. And this is, I think, a big kind of growing domain. There's been discussion about potential legislation in Congress about scraping. Those of you who are AWR students, it could be a topic you might want to look into. A lot of the discussion now about inputs into training AI systems, in particular kind of large language models like ChatGPT, a lot of those inputs are scraped internet data. And so there's a lot of discussion because scraping's a big business right now. Data harvesting, data mining is a big business, not least for training AI. So should it be a CFAA restriction? Is the Ninth Circuit correct, first of all? And second of all, maybe even more importantly, should Congress think of amending the statute? So look at the videos on scraping and then come back to this and you'll understand the facts a little bit better, right? HiQ is scraping information from LinkedIn profiles. Why, right? You all have LinkedIn profiles, I'm sure. If you don't, you should, but I do, all professional people do. And well, there's a lot of publicly available information. Your name, the company you work for, past employers, educational history, a lot of other things like that. HiQ scraping that information and then using it to feed really an AI system, but some kind of back-end, data analytics system to then produce aggregated and reported data to others for consumption, right? They're selling these reports, say, to potential employers, in this region of the country, there's X number of people with X number of educational credentials in X field, right? Things like that. LinkedIn, this violated LinkedIn's terms of service, this scraping. LinkedIn also configured something called the robots.txt file to prohibit this kind of bot access. Now, again, if you haven't read the Google bot.txt document that I put in the readings, pause here and go back and read that. You don't need to read it in any technological depth, just kind of skim through it. Bottom line is this is a long-standing protocol, a file that you can include on your website that will give instructions to crawlers and scrapers as to what they're entitled to do or not entitled to do. Now, you might ask, okay, LinkedIn had its robots.txt file configured to prohibit the kind of thing HiQ was doing. How did HiQ get around it? The robots.txt file, as the extension suggests, is a text file. It is not encryption or anything like that. It's giving instructions to a browser and to a bot as to what it's supposed to do. It's pretty easy, if you know what you're doing, to configure a bot to circumvent a robots.txt file. LinkedIn also had taken some other steps, specific IP blocks. If they knew that bots and crawlers were coming from specific IPs, they had blacklists. They would throttle accounts that weren't on the blacklist but that were suspect. If they did find accounts that were scraping data, they would suspend those accounts. So they were doing really what I would call kind of hybrid policy and technological barriers. I really think this is, if I were the judge, I would say this is a case that falls in between technological gates up and technological gates down. I would say this is a case that falls between technological gates up and technological gates down. The Ninth Circuit kind of blew past all that, and at the end of the day said, nope, HiQ scraping was really gates up, because at the end of the day, these are public web-facing websites. The LinkedIn profiles are publicly accessible to anyone, and the Ninth Circuit categorizes, basically open to the general public, specific authorization, and you have it like a password, or specific authorization and you don't have it. And it would be only this latter category where there's some specific authorization, a decryption key, a token, password, or something like that. All right, so in our discussion for this week, HiQ is not the last word. It is one case in the Ninth Circuit. And in fact, if you look at the procedural posture of HiQ, it's really only deciding the context of a preliminary injunction application. So it's only looking at likelihood of success on the merits. It's not even really deciding the merits as such. So this issue is going to continue to be litigated in the Ninth Circuit, and it's going to be litigated in other circuits, and it's an issue that's being discussed in Congress. And so this will be our discussion prompt for this week, which is whether the CFA currently prohibits this kind of scraping, and if not, whether there should be some prohibition of it or not. And your position may be, as many in the data industry is, well, no. I mean, if you put something out there, it's accessible on the internet, it's fair game. But you might have a different view. All right, so I will see you online this week.